No plans to manipulate Kanu's trial. IPOB's lawyers speak. Good day, my dear listeners. Thanks for joining. I bring to you another interesting news that states that no plans to manipulate Kanu's trial. IPOB's lawyers speak. Moving on to the full details. Kindly please ensure you like, subscribe to this channel and share. Contrary to recent claims that the indigenous people of Biafra, IPOB, is planning to manipulate the ongoing trial of its leader, Mazi Nnamdi Kanu, the group, in a statement by his counsel, Onyedikachi Fedi, argued that the rule of law must be adequately followed in the administration of justice in his case. Ifedi, in a statement, kicked against an article circulating on social media alleging IPOB's propaganda in the hearing of Kanu's trial. Poverty of legal reasoning. In the article, it is laughable that an individual bereft of legal training presumes to dismiss complex constitutional questions with bare rhetoric. The pivotal issue: can a trial be sustained under a repealed law? Is the very fulcrum upon which Mazi Nnamdi Kanu's case turns. The law is settled that no one can be tried under a non-existent statute in Aoko vs. Fagbemi 1961-1, all NLR 400 at 403, the Supreme Court declared. It is a fundamental principle of our criminal law that a person cannot be convicted of a crime unless that crime is defined and the penalty therefore is prescribed in a written law. The Terrorism Prevention Amendment Act 2013, the charging statute, has been repealed. It is dead law. A dead law cannot found a living prosecution, Ifedi explained. He added, Justice Binta Lunyako's recusal. The propaganda piece conceals the notorious incident where Justice Binta Lunyako sought to anchor her continued presence on instructions from the Chief Judge. Nnamdi Kanu rightly schooled early in open court. The Chief Judge is not the Court of Appeal if the state was aggrieved by her recusal. The remedy lay in appeal, not executive flat. This aligns with the Supreme Court's timeless admonition in Olalekan v. State 2001, 18 NWLR PT 746 793-812 per UY4 JSC. The independence of the judiciary demands that a judge must resist every external influence. Once he cannot decide for himself, he ceases to be a judge. It was precisely this legal humiliation that forced the Chief Justice to transfer the case filed to Justice James Omotosho. That was not intimidation. It was judicial rescue. On the so-called evidence standard, the prosecution's evidence is a disgrace to criminal jurisprudence. No bullet, no bomb, no arson, no destruction, only doctored DSS broadcast that collapsed at the threshold of admissibility. The Supreme Court has long settled that evidence must be relevant, admissible, and credible. In Subaru v. State 2010, 8 NWLR PT 1197 586 at 613 per Adekeye JSC. The primary duty at the court is to ensure that justice is done by admitting only such evidence that is relevant, admissible, and credible. Anything short of this is a miscarriage of justice. Discharge equals acquittal. The most ignorant assertion in the propaganda article is that an appellate court discharge is somehow not an acquittal. Nigerian case law is emphatic that a discharge on jurisdictional or substantive grounds terminates proceedings absolutely. In Abacha vs. State 2002, 11 NWLRPT 779, 437 at 499, the Supreme Court held, where a court of competent jurisdiction had discharged an accused person on the merit or on want of jurisdiction, such discharge amounts to an acquittal. Similarly, Linibori vs. Adbi 2004 6 NWLR PT 866878 at 106, the Court of Appeal affirmed a discharge founded upon a finding of want of jurisdiction is tantamount to an acquittal to try such a person against to offend Section 36 9 of the Constitution. Thus, the Court of Appeal's October 13, 2022 discharge of Nnamdi Kanu was in law and acquittal. The Supreme Court, December 15, 2023 somersault under political pressure was per inquirium and unconstitutional. My dear listeners, now I've come to the end of our today's news. Please do drop by the comment section and let us know what your view is all about. Thank you for listening.